matter of Dairy UK against Oatly.
Lord Burrows will explain the court's judgment.
This case concerns the validity of a trademark. In April 2021, Oatly, a Swedish company, registered the trademark post-milk generation for use in relation to oat-based food and drink and for use in respect of T-shirts. In November 2021, Dairy UK Ltd, which is the trade association for the UK dairy industry, applied for a declaration that that registration was invalid. It's now accepted that the trademark is valid for use in respect of T-shirts, but the question on appeal is whether the trademark is valid for use in relation to oat-based food and drink. Under Section 3, subsection 4 of the Trademarks 1994 Act, quote, "A trademark shall not be registered if or to the extent that its use is prohibited in the United Kingdom by any enactment or rule of law other than law relating to trademarks." The relevant enactment in question here is EU Regulation number 1308 of 2013, which I shall refer to as the 2013 regulation. Amongst other things, this regulates the use of dairy terms, such as milk, in relation to the marketing of agricultural products. It's common ground that subsequent to Brexit, the 2013 regulation is assimilated law within the UK. In other words, with minor subsequent amendments, it is to be treated as part of domestic law. Under point 5 of the 2000 regulation, the designations referred to, which include milk, may not be used for any product other than those set out. There's then a proviso which reads that, quote, "This provision shall not apply to the designation of products when the designations are clearly used to describe a characteristic quality of the product." Dairy succeeded before the hearing officer in the Intellectual Property Office in having the trademark declared invalid in respect of oat-based food and drink. But that decision was overturned in the High Court by Mr. Justice Richard Smith. His decision was in turn overturned by the Court of Appeal. Oatly now appeals to the Supreme Court. The Supreme Court unanimously dismisses Oatly's appeal. The judgment is given by Lord Hamlin and myself, with whom Lord Hodge, Lord Briggs and Lord Stevens agree. Ground 1 of the appeal focuses on the proper interpretation of the term designation in point 5 of the 2013 regulation. Counsel for Oatly submitted that designation here means the name of a food or drink. Milk, cream, butter, cheese, yoghurt are all examples of designations, as would be lamb or beef in relation to meat, because they're all names of food and drink. In contrast, he submitted, post-milk generation is not the name of a product. It does not name or even describe a food or drink. If one were to ask, in respect of oat-based milk, what is that product? The answer, it's post-milk generation, would not answer the question because it would not name the product. The name of the product would be oat-based milk, not post-milk generation. It follows, according to Oatly's submission, that point 5 of the 2000 regulation does not prohibit using post-milk generation in respect of oat-based food and drink. The Supreme Court rejects that submission. The natural meaning of the term designation in its context is referring to the use of the designation, here the term milk, in respect of a food or drink, rather than the naming of the food or drink. The prohibition bites where the designation has been used for a food or drink, and it is not necessary that it has been used as the name of a food or drink. That meaning is also consistent with the purpose of point 5, which in respect of milk is to set out fair conditions of competition. That purpose is distinct from protecting consumers from being deceived. As it uses the term milk as a designation, the trademark post-milk generation does therefore fall within the scope of point 5 of the 2000 regulation and is prohibited unless it is saved by the proviso to point 5. We therefore move to ground 2 of the appeal, which is concerned with the meaning and application of the proviso. To reiterate, the designation is not prohibited if it is, quote, clearly used to describe a characteristic quality of the product. Counsel for Oatly submitted that the designation post-milk generation in relation to oat-based food and drink is being clearly used to describe a characteristic quality of the product, namely that it's milk-free. The court rejects that submission. It's far from clear that that trademark is describing any characteristic of the contested products. Rather, on its face, it's focused on describing the targeted consumers, and in particular, those younger consumers who may be said to belong to a generation for whom there are, in contrast to past generations, widespread concerns about the production and consumption of milk. Insofar as it's describing a characteristic quality of the product, it's doing so in an oblique and obscure way, and is certainly not doing so clearly. Even if post-milk generation were to be regarded as referring to the milk-free characteristic of the contested products, that characteristic is not being described clearly. In particular, does it mean that the product is entirely free of milk, or only that the milk content is low? Take an analogous hypothetical trademark, post-alcohol generation. If that designated a drink, it would not clearly indicate whether the drink is merely low alcohol or has no alcohol. The proviso does not, therefore, save the trademark, and Oatly's appeal fails.
The court is now adjourned.